and we're going to get started while the rest of the people get logged in. First of all, I wanted to thank everyone for joining the CLE. Before I begin introducing our wonderful presenter, Attorney Jennifer Stone, I would like to make just a few announcements. First, for attorneys seeking CLE credit, today before 6 p.m., I'll send an email with your certificates of attendance for those who completed the full 60 minutes. And as a reminder, there's no partial credit, so please be sure to stay for the entirety of the presentation. In the same email, I'll send a PowerPoint presentation kindly provided by Jennifer. And additionally, I'll provide a link to our YouTube channel for those who wish to either rewatch the presentation or share it with others. The presentation will provide foundational knowledge on the divorce process, and the recording of this presentation will be used on court kiosks across the state of Arkansas. Therefore, we ask that you do not provide any personal identifying information when asking your question. When you ask a question, simply put it in the chat as a hypothetical. For those who are not attorneys, this means making your question like, if person A wants to divorce person B, how can she start the process? I'll be monitoring the chat throughout the presentation, and I will ask your questions at the end of the presentation to ensure we cover all of the material. Also, if you're a member of the public and wish to make a specific question in private, you can call Arkansas Legal Services to see if you qualify for their services, or consider signing up for the Arkansas Free Legal Answers program. The links to both are on the top of the chat. Finally, given that this week is Pro Bono Week, I would like to take a minute to encourage all of our attorneys to consider signing up for the Arkansas Free Legal Answers program or volunteering for the Center for Arkansas Legal Services. These are definitely fantastic opportunities to give back to the community and to obtain CLE credit for your pro bono work. If you're interested in volunteering, just email me at edith@arkansasjustice.org, or you can also go to the website for the Center for Arkansas Legal Services. Well, now, without further ado, let me introduce our presenter, Attorney Jennifer Stone. Jennifer is a U of A graduate with a BA in Political Science. She received her law degree from the William H. Bowen School of Law. Jennifer has practiced law for 28 years in her hometown of El Dorado. 27 of those years, Jennifer has been doing family law at the Center for Arkansas Legal Services. In her personal time, Jennifer enjoys spending quality time with her husband and daughter. Her daughter is a senior in high school, and she is her world. Jennifer and her husband are proud band parents, and so on Friday nights during football season, you can either find them behind the concession stand or following out the band in a football game. Jennifer is currently a member of the board of South Arkansas Arts Center and an active member of First United Methodist Church in El Dorado. Jennifer, thank you so much for making the time, and the audience is all yours.
Thank you, Edith. I appreciate your allowing me to talk with everyone about divorce law. So I'm just going to jump right in. We have a lot of material to cover, and I'll be happy to answer questions for as long as we have them after I'm done. So we'll get started. So I need a divorce, or my client needs a divorce. What do I do? Where do I start? Step one is to prepare the complaint for divorce. And how do you do this? The first step, go to arlawhelp.org under Family Law, and there is a divorce packet that you can print off. There is also an uncontested divorce testimony sheet that you'll want to also print off. And this information is going to show you how the complaint should look, how it should be organized. Your complaint may be typewritten or neatly handwritten. You need to make sure that you leave a 2-inch margin at the top of your first page, so the clerk will have room to put the file mark stamp. These forms are free. Please do not pay people for forms, because usually the forms that you pay for are not going to satisfy Arkansas law. Next, you're going to go to, you're going to need some more documents. So you'll go to arcourts.gov. This is the Supreme Court's website. And at the top right of the screen is a section called Forms. You're going to click on that, and you're going to scroll down to get these documents listed below. Go ahead and get those printed out. And so after everything is drafted and filled out, you file you take your cover sheet that you've printed out, your confidential information sheet if you have children, and your complaint for divorce, along with the filing fee, to the circuit clerk's office for filing. So you're going to file in the county where you live. So if you're filing a divorce, it's simply go to the circuit clerk's office in the county where you live. Let's talk about drafting the complaint. There's going to be a lot of things that you're going to want to include in your complaint. At the top of your document, you're going to have the county and state where you reside. You're going to also have it's going to say circuit court of whatever county, family domestic relations division, and then you're going to have the names of the parties. You're going to include your date of marriage, the date that you last separated from your spouse. Going to have a section on grounds for divorce. And depending on your case, if you have children together, you're going to have the children's names and birthdays. Now, when I first started practicing law, we put the child's entire name and full date of birth. Now, for privacy reasons, we just use the child's initials and the year they were born. You're going to want to have a statement regarding custody, visitation. You're going to, if you want child support or spousal support, you will need a section for that. You're going to request that any marital property or debts be equally or equitably divided by the court. If your spouse has a 401k retirement fund through his or her employment, you're going to ask that that be equally divided. If you want your former or maiden name restored to you, you're also going to put that in your complaint. Now, to the complaint, you're going to attach what's called either a mutual restraining order, or sometimes you'll hear it referred to as a standing order. The circuit clerk can provide this document for you. Every judge or judicial district has a standing order that they use. And also, if you're going to need a temporary hearing, you'll want to ask for that in your complaint. You're going to sign your name, put your address, your phone number, all your contact information, and sign it. And then, especially if children are involved, you're going to want a verification clause. And so after that, you will make a statement that all the information contained in the complaint is true and accurate as far as you believe. And then you're going to want to have your signature notarized. Filing fees. If you're filing in person, the filing fees are usually $165. If you're filing online, it can be up to $185. You're going to need the AOC cover sheet, which you printed that off at arcourts.gov. And also, if you have children, you're going to need to fill out the confidential information sheet. You're going to turn these documents in when you file your complaint for divorce. Also, at arcourts.gov, you've already printed out your official form of summons. So depending on what county you live in, the clerk might prepare the summons for you, or you may be expected to present the summons to the clerk for the clerk's signature. Sometimes you'll be charged a fee for the summons. And then here also, we have that mutual restraining order, also called the standing order, that needs to be submitted. And some courts require parents to attend a parenting class. I'm in the 13th Judicial District, but I practice outside of the 13th Judicial District also. And in the 13th Judicial District, a parenting class is not required by the courts, but the circuit clerk will let you know if it is in your county. The next step is to serve the defendant, the person that you want to be divorced from, serve them with the complaint and the summons. So there are a couple of ways that you can do this. You can either take the complaint and summons to the sheriff's office in the county where the defendant lives. You will be charged a fee for this service. Or you can send it by certified restricted delivery mail. And the defendant may also want to sign a waiver if the case will be uncontested. The waiver form can be found at arlawhelp.org. When you serve the defendant, let's say you serve them by certified restricted delivery mail, they will sign the green card that is attached to their letter. And when this is returned to you, just put your heading at the top of your page in the circuit court of whatever county, domestic relations division, Jane Doe versus John Doe, put your case number, and then write proof of service. And you're going to tape that green card to that sheet and file that with the clerk as your proof of service. Or if you receive the summons back from the sheriff's office, you will file that as your proof of service. There is not a fee for filing the proof of service. But do know that from the date that you file the complaint, you have 120 days to get that person served and get that proof filed with the court. What happens if you don't meet that deadline? If you do not get an extension for service by the court, you will have to dismiss your case and start all over. And then the next section just talks about the defendant can sign a waiver and consent, and that needs to be filed with the court also. Now, after the defendant is served, he or she has 30 days to file an answer. If the defendant is incarcerated at the time of service, he or she will have 60 days to file an answer. Once this time period passes, if the defendant has not filed an answer, you can go ahead and call the judge's office and request an uncontested hearing date. If the defendant does file an answer, you can call and request a hearing date and let the case coordinator know which issues you and the defendant do not agree upon. So, for example, you can tell the case coordinator, I want sole custody, but he's asked for joint custody. Or we don't agree on how the property should be divided. And that way, the court will know what issues need to be litigated and approximately how much time you'll need for that hearing. So let's go back and talk about all the things that must be proven in order for a divorce to be granted. The first thing is residency. You must live in the county where you file. You must live there for 60 days before you file and a total of 90 days before your divorce is final. So even if your spouse does sign that waiver and consent, you must still wait the 30 days from the date the complaint is filed and the decree is entered. And again, residency means actual presence in the state. You have to live in that state and county where you file. Next, grounds for divorce. You can see here there are 9 grounds for divorce in Arkansas. We're going to talk about general indignities, and we're going to talk about 18 months continuous separation. Those are the most, I won't say popular, but those are the most used grounds because they're the easiest to prove. So also, the grounds have to have occurred within 5 years before you file your complaint for divorce. So let's talk about general indignities. This simply means that your spouse has treated you in such a bad way that it renders your life intolerable and you cannot stay married to this person. It has to be more than just an occasional disagreement. Your spouse must have treated you with rudeness, contempt, neglect, open insults, and this behavior must have occurred on a regular basis. Can't be a one-time incident. It has to occur on a regular basis. The court has further defined general indignities as habitual, continuous, permanent, and plain manifestation of hate, alienation, and estrangement on the part of one spouse that is sufficient to render the other's life intolerable. For example, here at Legal Services, I deal with domestic violence. And if there's domestic violence in your marriage, you are probably going to meet the definition of general indignities. But what you want to do, especially if your case is contested, you have to give the judge, and even if it's uncontested, you have to give the judge examples of what your spouse did to you that rendered your life intolerable. So you can't just get up there and say, we had domestic violence in our marriage. The judge wants to hear examples of things he did to you, if you received any injuries, and those types of things. So let's look at some cases. That'll help us have a better understanding of what general indignities means and what corroborating testimony is. So Forsgren versus Forsgren, the wife was guilty of excessive consumption of alcohol and drugs. The Court of Appeals upheld the trial court finding that drunken conduct may be proved along with other acts to establish general indignities. So it's not enough to just say, my spouse was drunk all the time. Well, the judge is going to want to know, how did that affect you? How did that make your life intolerable? You know, were they a raging alcoholic? Did they cuss you out in front of other people? Did they put you down? Were they violent? Things like that. So it can't just be a general statement. You have to give the court more details. Copeland versus Copeland. This case addressed corroborating testimony. The Court of Appeals held that it must focus on specific language, acts, and conduct that caused the problems in the marriage and who was at fault. So one person has to be more at fault than the other to be granted a divorce. And you have to give the court examples. What did they do? What did they say? Coffee versus Coffee. Husband told wife repeatedly that she was old and that he was tired of her. She would ask him about trips he made or his whereabouts, which were met with profanity and anger. He had slapped her on several occasions. He yelled, screamed, and cursed at her. He liked to party and had substantially increased his drinking. The Court of Appeals held that she did prove general indignities and that it is not necessary that the person to whom the divorce is granted be wholly blameless. So even though he may have been able to say a few bad things about her, he was more at fault, and so she was awarded the divorce. Walton versus Walton. This case involved Larry and Deborah Walton. During the pendency of the divorce case, the trial court issued a mutual restraining order and ordered Larry to make the house payments since he was living at the house. Deborah filed a motion for contempt for him violating the restraining order and for failing to make the house payments for 3 months. Deborah argued that he violated the mutual restraining order by calling and emailing her numerous times and by going to her apartment to harass her, and that he was 3 months behind on the mortgage payments while he continued to live in the house and he continued to be employed. The trial court sentenced him to 30 days in jail, suspended upon his future compliance. And for the house, he was fined $500 plus $1,000 for her attorney's fees. Larry appealed and said in his first argument that she did not put any proof on that he hated her. So this is what Deborah did prove, according to the Court of Appeals. That prior to marrying Deborah, Larry had a relationship with the woman, we'll call her former partner, and they had children together. Former partner frequently called Deborah and threatened to beat her up. Once, Deborah had a confrontation with Larry's son, and she had to call the police. The former partner threatened to kill Deborah for doing that. And Larry just blew off the threats by saying, she's just jealous. Don't worry about it. Just ignore her. Larry would also consult with his former partner regarding important decisions regarding finances, involving Deborah's and his finances. Larry was described as disrespectful, demanding, and controlling. And then also there was an incident during the holidays in which, in front of Deborah's mother and Larry's children, where Larry yelled at Deborah and told her what she could and couldn't eat. He yelled at her in front of other people that she had to fix his plate and would make other demeaning demands of her. He also threatened to kill her if she left him. She then filed for an order of protection, and after that, when she was awarded the order of protection, he called her approximately 200 times, leaving voicemails accusing her of being in a cult and being a prostitute. Larry's second argument on appeal is that Deborah failed to corroborate grounds. Well, Deborah's mother was her witness, and she had been a personal witness to some of the abuse and the demeaning remarks. She testified that Larry was always so demanding of Deborah that he commanded her to fix his plate and the children's plates. Larry told Deborah what she could and could not eat. He was so arrogant and so demanding, she said. He would tell her, you can't have this, or you can't do this. You can't go out with your friends. He was overbearing. She said that Larry was lazy and demanded that Deborah do everything around the house, and he belittled her. The Court of Appeals found that Deborah offered proof of a continuing pattern of disrespectful, controlling behavior. He repeatedly dismissed her concerns about his jealous and threatening ex-partner. Larry did not consult Deborah about their financial issues. Instead, he consulted his ex-partner, and he humiliated Deborah in front of her mother and his children. He repeatedly violated the order of protection, and he threatened to kill her. So the Court of Appeals upheld the divorce because Deborah did prove grounds, and she did provide sufficient corroborating testimony through her mother. And so from this, make sure that if you have a contested divorce, that your witness who's going to corroborate your grounds, they have personal knowledge of the bad acts that your spouse committed. Pomeranian versus Pomeranian. The wife testified that the husband was constantly angry at her. He would not speak to her for days at a time. The behavior happened every 2 to 3 weeks. He openly criticized her housekeeping and the way she cared for the children. He showed her little affection. On 2 occasions, he lost his temper and became physical with her. They had a 3-month period of separation and later a 5-month period of separation. During that time, he paid no child support or spousal support. As a result of the constant fighting, she had developed health problems. The Court of Appeals found that she did prove grounds of general indignities. It was these constant bad acts over and over again that led to a finding of general indignities. The next case I cited is Gunnell versus Gunnell. And now this was a contested hearing. And this is the question and answer between the attorney and the client. So the attorney asked, did you all have problems during your marriage? The client said, yes, sir. The attorney asked, did these problems build up to the point where you all can no longer live together as husband and wife? And the client said, yes, sir. And then the attorney said, and this resulted in your separation? And the client said, yes, sir. The husband appealed this case, and the Court of Appeals found that there was insufficient proof of grounds and reversed the trial court's award of a divorce. The court stated that proof should be presented of specific acts, conduct, and language, which shows the rudeness, contempt, and indignities complained of. And even if your case is uncontested, you as the plaintiff, the person who wants a divorce, you must always prove grounds with those specific acts, language, and conduct. Ransom versus Ransom. The wife showed that the husband frequently directed his wrath toward her in a manner that embarrassed, humiliated, and frightened her. He publicly and privately lectured her over minor matters. He acted in a dismissive and suspicious manner by leaving the house for hours without an explanation, making late-night phone calls without saying to whom he was speaking, and being in the possession of a romantic card from another woman. He gambled frequently, and he couldn't account for a large portion of the couple's joint funds. The Court of Appeals held that all of those things taken together produced a cumulative effect sufficient to support the grounds of general indignities. Coker versus Coker. The wife presented evidence of husband having an ongoing affair. He would lie to his wife about where he was. When confronted, he would attack her verbally. He got in her face, and she was fearful that this type of behavior would continue and get worse. She offered evidence of his rudeness, unmerited reproach, studied neglect, and settled hate. Her mom testified that her daughter had become extremely nervous and that he was inattentive to her daughter and did not seem to care one way or the other about her. The husband appealed, saying that she did not prove general indignities. The Arkansas Supreme Court held that the conditions arising from adultery gave rise to general indignities, and that the corroborating testimony from her mother was sufficient. The next case is Copeland versus Copeland, which held, the Arkansas Court of Appeals held that corroborating testimony must focus on the specific language, acts, and conduct again, and who was at fault. Lundy versus Lundy. The parties were married 8 months before they separated. The wife filed on the grounds of general indignities. She testified that she wanted a divorce because he was overbearing and wanted to discipline her by having a court commit her somewhere. She stated that her husband was angry because she wouldn't let him be a part of her counseling sessions to deal with the death of her father. He threatened to burn her collection of the Waltons DVDs, which she watched for calming reasons. Her husband thought she was stupid and the decorations in the house were stupid. He quoted Bible verses to her and said that she wasn't a Christian because she sought counseling for depression. He told her that he was the man of the house and that she needed to remember that. The wife's sister was her corroborating witness. She testified that since her marriage, her sister was sad, nervous, and scared. She admitted that she didn't witness any discord, but would talk to her sister after an argument. The wife kept telling her sister that she was scared. The Court of Appeals agreed with the appellant, with the husband, that the wife did not provide any proof corroborating her grounds because the witness's testimony was based on what she was told and not what she saw. So, usually when someone is abusive, they're not going to do it in front of an audience. But today we have these wonderful things called cell phones, and conversations and video can be recorded of this abuse. And that is very powerful evidence in front of a judge. And finally, Wood versus Wood. This was a contested divorce. The witness affidavit, a witness affidavit was introduced to corroborate the testimony of the plaintiff as to the length of separation. This case was appealed. The Court of Appeals reversed the trial court's decision, stating that a witness affidavit is not sufficient evidence for corroboration of grounds. You've got to have your witness there in person to testify. And I mentioned the other commonly used ground was 18 months of continuous separation. Just like the name says, it means you and your spouse have lived separate and apart for 18 continuous months. That means no sexual contact, no spending the night together, living separate and apart. So, what do you need to prove if your divorce case is uncontested? You and your witness need to testify that you have lived in that county for at least 60 days prior to filing your divorce case, and that 30 days have elapsed from the filing of your case to the entry of the divorce decree, and that you and your spouse have lived separate and apart from the date of the separation that you put in your divorce complaint. And you should testify that your grounds occurred within the last 5 years. And then also, if you file on the grounds of general indignities, what did he do specifically to render your life intolerable? You cannot remain married to him. What were the bad acts that he did? And then if you have custody and property division, debt division, and other issues, then those issues need to be discussed as well. And so what if your divorce case is contested? You're going to need to prove everything that I just said for an uncontested case, but you're going to need to have your witness corroborate grounds. Now, if an attorney is on the other side, a lot of times the attorneys will agree, will waive corroboration of grounds. And so if that's on the record or in writing, then you do not have to have a corroborating witness in a contested case. But remember, you've got to give specific bad acts. And these are things that occurred over and over again, not just a one-time, two-time occurrence. It was continuous, and it just made your life intolerable. So what are some of the other issues that need to be addressed in a divorce case? If you have children together, the court is going to need to make a custody and a visitation determination. For a court to be able to do this, the court must have jurisdiction. In order for a court to have jurisdiction, the children must have lived in the state of Arkansas for at least 6 months before your divorce is filed. And once the court does make a determination, the court will continue to have jurisdiction unless you move out of state, and then the judge in the new state and the judge in Arkansas would talk and decide who needs to have jurisdiction at that point. Custody of children. How is custody decided in Arkansas? The bottom line is, what is in the children's best interest? The court will consider many factors. Here in Hortello, the court looked at the psychological relationship between the parents and the child, the need for stability, continuity in the child's relationship with the parents and the siblings, past conduct of the parents toward the child, and the reasonable preference of the child. Now, best interest, what does that mean? Basically what it says, it's defined very broadly. When you go before a court on a custody case, just expect if you have any skeletons in your closet, they will come out, and all things are discussed when it comes to the children. Also, there's a presumption that if there's been a pattern of domestic violence, the abusive parent should not receive custody. So let's talk about the main factors that the court will consider in a custody decision. And this is not everything. These are just some of the main things the court will consider. First of all, moral fitness. And this includes, is the parent honest? What is the character of the parent like? Does the parent show compassion towards the child? Is the parent sober? That's a big one these days. Does the parent take the child to church? Does the parent have a criminal record? Another issue the court will consider is stability. And this is employment stability. Is the parent able to provide financially for the child? What about residential stability, school stability? Is the parent moving the child from school to school all the time? That's not good. What about the mental and physical health of the parents? And also partner stability. If parent is moving from partner to partner to partner and the child is living with that parent, that is not going to be a stable type situation. Number 3 is love and affection. The court's going to look at what kind of attention is given to the child, who's spending quality time with the child, who is the primary caregiver, who's that parent that's helping with the homework at night, and do the parents provide proper discipline for the child, those types of things. Home environment. Do you have a safe environment? Does the child have a room of his or her own? Does the child have his or her own bed? These are important things that the court will look at. Usually, when I'm trying a case, I will have my client take pictures of the inside and outside of the house so that the court will have an idea, yes, this is the proper place. This looks like a safe, clean environment for children. Yes, they have a fenced-in backyard with a swing set where the children play and that type of thing. Painting that picture for the judge who does not know your client or their situation is very important. And then finally, child's preference. I have clients all the time that ask me, how old does the child have to be before they can tell the judge who they want to live with? Well, there's no magic age. The court may consider the child's preference, but does not have to. You know, a lot of the times children don't really know what's in their best interest. They might want to live with a parent who's not going to set those rules and those boundaries. And so many times a court would appoint what's called an attorney ad litem, and that's an attorney for the children. And that attorney can go in and visit with the children and each parent in their respective homes. They can ask a bunch of questions. They can talk to the children in front of the parents and alone. And so they get a really good idea of what's going on in those households. Arkansas law favors a true joint custody arrangement, but you still have to meet the best interest of the child. So it's not mandatory. And what a true joint custody parenting arrangement is, it's usually a week-to-week exchange of the children. It's evenly divided parenting time. But in order to get this, the parties have to be able to cooperate. They have to be able to communicate effectively. The presumption that this arrangement's in the best interest of the children is rebuttable. So, for example, if one parent is physically abusive to the other or to the children, it would not be in the children's best interest to be with the abusive parent without supervision. Or the parties may agree that one parent should have primary custodial custody of the child because maybe their work schedule doesn't allow them to be home with the children. Maybe they work some of these working for a plant. You might have a swing shift and where you have to be gone overnight. You got the night shift. You're not there to be with the children. And so some parties just agree that maybe the child needs to live with one parent over the other. Visitation. Generally, a non-custodial parent, the parent who does not have primary custody, will get visitation with his or her children. Now, there's no statewide visitation schedule. Each judge or judicial district has what they call their standard visitation schedule. And this usually looks like alternating weekends, alternating holidays, several weeks during the summer, and sometime during the week sometimes. Now, there are cases where supervised visitation is necessary, and even no visitation may be warranted. We see this in cases where a parent is abusive or has a current substance use disorder. So what happens if the court awards joint custody and then something changes which affects the welfare of the children? Just know that custody can always be revisited and changed. So just because some circumstances are one thing 1 month, maybe 6 months down the road, things have changed and it's no longer in the best interest of the children for that joint custody award. And so what do you have to be, what has to be proven? A material change of circumstances and always the best interest of the children. And how does the court define what is material change of circumstances that would warrant a change of custody? The first case I cite is Harrington versus Harrington. Mom filed for a change of custody because her girls, who were in the custody of the father, her girls were beginning to enter puberty, and she felt like it would be better for the girls to be with her. The Court of Appeals held that a change of custody was not warranted. Durham, dad files for a change of custody because mom filed a petition to relocate. So know that if you are given custody and you need to move out of the state and you're not going to be able to adhere to that visitation schedule that the other parent has, you're going to need to get the court's permission to do that. Mom was able to prove at the trial court level that she was not trying to frustrate dad's visitation rights. The Court of Appeals held that a change of custody was not warranted. So just because mom wants to move out of state, that does not automatically give the other parent the right to have custody. Stone versus Steve. Mom marries a guy who does drugs and the child witnesses the drug usage. The Court of Appeals found that there should have been a change of custody to dad. Walker versus Torres. Dad filed for a change of custody because mom exhibited hostility, a lack of cooperation. She withheld visitation and failed to maintain a stable home. The Court of Appeals found that custody should be with dad. Alphen versus Alphen. Dad filed for a change of custody because mom had 6 or 7 residences in a 6-year period, and dad could provide stability. The Court of Appeals held that dad should have custody. So that residential stability is very important. Holmes versus Holmes. The trial court gave custody to mom. Dad filed for change of custody afterwards because mom violated the court order by cohabitating with 6 different sexual partners, and she failed to get along with dad. She also lacked financial, residential, and employment stability. The trial court, for some reason, left custody with mom. The Court of Appeals reversed the trial court and said dad should have custody. I'm not sure what happened at the trial court level, but there was a provision in the divorce decree that said she'll not have spend the night company of the opposite sex with the children there, and she did that and also had all those other issues. So anyway, the Court of Appeals gave custody to dad. Sharp versus Keeler. The parent alienated a child from the other parent, and the Court of Appeals found that a change of custody was warranted. Now, that is a quick way to lose custody of a child, is to alienate a child from the other parent. And this is done by talking bad about the other parent in front of the child, or at getting back to the child that you've talked bad about the other parent, or you are posting things on social media, can I say, please don't do this. It will come back to haunt you. And just be real positive to your child about the other parent. Even if you don't have a lot of positive things to say, please don't say anything negative. It's very harmful for the child. Davis versus Sheriff. The child's stepfather was convicted for child endangerment against the stepfather's biological son. A change of custody to dad was warranted. And along those same lines, in Peck versus Peck, mom's new husband was a registered sex offender. Dad gets custody. Quarter versus Quarter. The father was found unfit because he physically abused mom in front of the children. The trial court found the father to be the aggressor, supporting the legislative directive that it is not in the child's best interest to be in the custody of an abusive parent. If you can show a pattern of abuse by one parent to the other, which is seen by the child or affects the child, the abusive parent should not get custody. Child support. The purpose of child support is to meet the child's reasonable needs. The term income is very broad. It encompasses all the income that a person receives. If the parent without custody is incarcerated, he or she will not have to pay child support during the incarceration. Now, after the incarceration is when I would send my clients back to the child support enforcement to get child support started again. If you have a child support issue that needs to be litigated, prior to your hearing, you're going to fill out what's called an affidavit of financial means. And I've already mentioned this form earlier. You can download it and print it at arcourts.gov, which is the Supreme Court's website. You go to forms, and then you'll go to affidavit of financial means. You'll fill this out. You'll have your signature notarized on it. Be sure to attach proof of income. So like your last 3 pay stubs or a income tax returns. And that goes to the court. Also, while you're on that website, you can scroll down to child support calculator. Now, there's going to be 2 different forms that you can use. One is a true joint custody. This is if the parents have 50% equally divided time with the child. But if you have one parent who's the primary custodial parent and the other parent who just gets visitation, you're going to go to the other form, which is one main custodial parent. So you're going to need to know your gross income. This is your income before taxes, and your spouse's gross income, as well as the amount that you pay for daycare and for health insurance for the child. If you have all this information, you can put this in the chart, and then you will come up with what the law says, who should pay child support and how much. Also know that child support can be extended beyond the child's 18th birthday. For example, if the parties agree that it should extend past that, maybe the child is still in college and the parents, want to still provide that, or if the child is disabled. The court may also deviate from the chart if there's circumstances that warrant it. Now, let's say you're receiving child support and you or your ex has a significant change in income. You have to prove a material change in circumstances. And what does that mean? A 20% or more change in your income. So it's not just I received a little cut in pay or I received a little cost of living increase. That's not going to be enough to warrant a change in custody. I suggest to all my clients that they use the Office of Child Support Enforcement for assistance in collecting and modifying child support. The Office of Child Support Enforcement has the capability to intercept income tax returns. They can put liens on real and personal property to help you collect. They can suspend driver's licenses and professional licenses, and they can refer a parent for criminal prosecution if they do not pay their child support. Spousal support and alimony. So the purpose of alimony is to rectify the economic imbalances in earning power and standard of living in light of the particular facts of each case. So a lot of times my clients will come to me and say, I want alimony, and he treated me really in a bad way and I deserve alimony. Well, the consideration that the court has for alimony is the need of one spouse versus the ability of the other spouse to pay. Also know that temporary alimony can be awarded in Arkansas during the pendency of the divorce. There are a lot of factors that the court can consider, but the bottom line is the court's going to look at the financial circumstances of both parties. They're going to look at what assets you have, what liabilities, what debts do you have, what are the health conditions of the parties. If one party is disabled and not able to earn an income, the other party, if able, may have to pay spousal support. The court's going to look at the duration of the marriage. How long have you been married? And the earning ability and capacity of the parties. So fault is not a factor unless it relates to the need or the ability to pay. And also know that there's no mathematical formula that the court uses to come up with this amount. When you fill out that affidavit of financial means, that's one thing that the court is going to be looking at to see how much income do you have, what are your needs, and the courts need to be able to have flexibility in deciding this on a case-by-case basis. Know that alimony can be permanently awarded or on a rehabilitative basis or as reimbursement. So rehabilitative alimony is alimony that's payable for a short time. It's going to be for a specific period of time, and the recipient is going to be exercising reasonable efforts in a position to be able to support him or herself. Alimony, like child support and custody, is always subject to modification. You need to have a material change of circumstances in order to modify. For example, the economic condition of either party changes. That can warrant a change in alimony. Alimony can be terminated upon several things. Arkansas Code Annotated Section 912.312 sets out multiple contingencies that may trigger the automatic cessation of alimony unless otherwise ordered by the court. So you need to pay special attention when you draft your divorce decrees that you are specific. If upon death of one of the parties, alimony ceases. If the person receiving alimony remarries, alimony ceases. Or the parties need to come back to court and let the court decide if alimony ceases. So just know that you need to really watch your language when you're drafting those decrees when it comes to alimony, because that'll be very important. Let's look at property and debt division. So the property that you owned before you got married is called premarital property. You keep what you had before the marriage. He keeps what he had before the marriage. Anything that you and he acquired after you got married is marital property. And why is that important to know the difference? Because the premarital property is yours. The marital property is subject to the court dividing. So there's two exceptions to this general rule. After you're married, if you receive a gift or if you receive an inheritance during the marriage, this will not be considered marital property, but it can be converted to marital property. So if you inherit money, but you put that money in a joint banking account with husband and wife's name on it, you are commingling those funds with the marital funds, and it becomes marital property, and the court can divide it. The first case I cite is McKay versus McKay. The husband had a banking account prior to the marriage where he put his federal disability checks. So he had money in that account coming into the marriage. After the marriage, he put the wife's name on it, but he was able to show the court that he still controlled those funds, even though her name was on the account. The trial court found that the account and all the property purchased with those funds were his separate property. They also bought a houseboat during the marriage. The husband used inherited money to pay for the boat, but the bill of sale was in both the husband and the wife's names. The trial court held that the boat was a gift to the wife and deemed it marital property, which was subject to division. And so the Arkansas Supreme Court agreed with the trial court. The account that he had before the marriage, he kept that separate. And even though her name was on it, she didn't access that account. And so that was his. And then the houseboat they bought, the court says, yes, that was a gift. You put her name on the bill of sale. And so that was marital property and subject to division. Filman versus Filman. This was a big fight over $100,000 worth of gold and silver coins, and then also over a retirement account. The husband had coins before they got married. The wife had coins before they got married. They got married. They commingled all the coins. And basically, the Court of Appeals found that the coins had been so commingled and for such a long time and to such an extent that the court couldn't decide whose coins belonged to whom. And so there was no way to separate them. And so the court held that it was marital and subject to division. The retirement account, the husband retired before they got married. After they got married, he didn't start drawing it until 2 years after he got married. So the court did hold that that those were his. Let's see. I just lost my train of thought. I'm sorry. Anyway, the wife did have access to the retirement account. They bought coins with that. They bought property with that money. And so because she had access to it and used that account, the court held that as marital property. I had a case recently where husband owned a house outright before they got married. After the marriage, he put my client's name on it. He added her name to the deed. At that point, the property became marital property. So when they divorced, she received half the value of the home. It's always better if the parties are able to separate the property themselves, because if not, the court will just order it be sold at a private or public sale. Your clients are not going to get what their property is worth, probably. And so it's important that they try their best to divide the property themselves. If you're in bankruptcy, the court will not divide this property or divide the debts. You will have to wait until the bankruptcy has been completed and then come back to court and ask for the court to make decisions on property and debt issues. What if you buy a car after you are separated from your spouse, but you're still married? This is marital property and it's subject to division. How will the court divide the property and debts? There's a whole laundry list of things that the court's going to look at. There's an example of a case, Doss versus Doss, where the wife asked for alimony, but the court wasn't convinced that the husband had the ability to pay the alimony. So he made an unequal division of the property and debts to financially kind of even things out. Okay, and when dividing a retirement account, you're going to need an additional order after your divorce decree is entered called a qualified domestic relations order. You'll hear this called a quadro. And a lot of times if you're dealing with a larger company, their legal department can give you a copy of the quadro that they use and they prefer that you use. So that'll save you a lot of time if you'll just contact the employer to get a copy of that. In order for the court to divide a retirement account, a party must be vested. When is a person invested in retirement? That's up to the party's employer or their plan administrator. How are debts divided in the marriage? Usually they're equally divided, but sometimes it's not equitable to divide it equally. And so the court's going to look at what would be equitable with regards to both of their financial situation. Also know that even though a court will assign a debt to be paid by a certain party, if your name is still on that debt, the creditor will still come after you for that debt. And so just be aware of that. Sometimes one party might go and have a piece of property refinanced in their name solely. So that won't happen. And that's always a good idea if that person can do that. If you want to be restored to your previous or maiden name, you do that in the divorce. And then finally, what happens if my ex does not follow the court order? You can file a motion for contempt. In that motion, you're going to ask for the court to find that they are in contempt for not following the order. You set out the provisions that have not been followed and the relief that you're seeking. So you may need to file a motion for contempt and a motion for change of custody all in one document. But basically, I think I'm out of time, and I think I've been through everything, and I will open up for questions.
Perfect. Thank you so much, Jennifer, for such a thorough review and for making it comprehensive too. Does anyone have any questions? If not, I'll start with some questions that I had prepared. So let's say a person lives under the same roof, but in separate rooms. Would that be, and there's no cohabitation, would that be sufficient to establish the 18-month grounds of separation?
Well, yes, but you're going to have a witness that knows that you have lived separate and apart. So you can do that, but I always would feel better if you do live in separate places. But sometimes financially that's not doable, and they're not able to do that. So yes, I would not have a problem going to court with that client, and as long as that they're not having relations, then I would be okay with that.
Perfect. Thank you so much. I don't see any questions in the chat, but here goes the next question. So when does an affidavit of financial means needs to be filed? What is like the deadline?
Okay. Usually once you ask for a hearing and then you tell the judge's trial court assistant what the issues are that need to be litigated, the court will send you that form, but it's good to have it on the front end so you know what the kind of information that you're going to need, and you can begin collecting that ahead of time, because the court will give you a deadline of when that needs to be returned to the court and filed. So, but I've seen the court in cases where people represent themselves, they will mail that out to the parties and ask for some other information also, like what are the issues, what are you asking for, that kind of thing. So the court will tell you when it's due, but definitely you need to have a copy of it filed before you go to court, before your hearing, and bring a copy with you to court.
Thank you so much, Jennifer. And last question, unless someone else has a question. What is the best way to serve a person that has unknown whereabouts?
Okay, now that can be tough. So you need to try to find the person. You make your best efforts to do that. You can serve them by warning order. And this is posted in the newspaper for 2 consecutive weeks, once a week. It's costly to do that. You have to get the court's permission to serve them by warning order, and you file a petition with the court requesting that you be allowed to do this, and you have to set out what steps have you taken to try to find this person. I've contacted their mama. I've sent it to their last known address. They're not there anymore. I sent it to their last known employer. They're not there anymore. I've done a Google search. I've looked on Facebook. Just, you have to show the court that you have made reasonable efforts to find the person. And if you're not able to, then you could file a warning order.
Great. And this will be kind of like a segue of that question. Someone from the audience asked, this is a notice of service question. If other spouse cannot be located or found, what would be the burden of proof? What does the court require?
Just like I said, to state the things that you've done to try to find that person and that you've been unsuccessful, I would try to serve them at their last known address and then have that come back returned, even if you know they're not there, because that is proof to the court that you've sent the sheriff to their house or you've sent a certified letter to their house and it's come back undelivered. The person no longer lives there, that type of thing.
Perfect. Does anyone else from the audience have any other questions? I don't see any other questions in the chat. So with that, we conclude the CLE. I wanted to thank Jennifer for making such a wonderful presentation, for taking the time. I know your schedule is super busy, so we thank you for that. And just reminding everyone, since we are commemorating Pro Bono Week, I will just make a call to action and ensuring that those attorneys that are here attending to the CLE, please consider joining the Center for Arkansas Legal Services pro bono efforts or the Arkansas Free Legal Answers program. We truly need your help.
Thank you.
Thank you so much. And I will send that certificate of attendance for everybody that attended for the full CLE shortly before 6 p.m. today. Thank you for joining us. Have a great day.
You too.
Bye.